Yo, what's up, everybody? It's Friday. Yeah. Well, end of the week. Who's looking forward to the weekend? Not so much. I got a lot of paperwork to do. Started working on Owen Schroer's certiorari petition 2-3 hours ago because, yes, I do get in the office at about 4:30 or 5, at least most days. And, that raises interesting First Amendment issues, but more about that on another time. Mike and I look at the papers in the morning and we send emails back and forth. He's earlier than me. And, what are we going to talk about today? It might surprise you to learn that sometimes until 5 minutes before the show, we're not sure. And that's the difference between Adam Carolla's podcast and ours. Preparation. I got the memo, Adam. We'll work on it. I got it, Tim Pool. We're coming for you. We're still figuring our SHIT out. And when we do, your ass is grass and we are the lawnmowers. But I digress. Liz Cheney.
Did Tim Pool say something to us?
No, but I mean, these guys have big pull, the kind of pull we aspire to. And the kind of pull we deserve, frankly, the kind of pull we deserve. But in any case, Liz Cheney's in the news. She's, once again got, Trump derangement syndrome. And because the Donald spoke, she wanted to get in his wake and speak back. So Trump said this week that if he were elected, he would free the January 6 hostages being wrongfully imprisoned. And Liz writes the following on, oh, please take that picture off. The broom closet developed legs. Liz writes the following on X. If your response to Trump's assault on our democracy is to lie and cover up what he did, attack the brave men and women who came forward with the truth, and defend the criminals who violently assaulted the Capitol, you need to rethink whose side you're on. Hint, it's not America's. All right, I don't want to be perceived as a misogynistic pig, but does she suffer from terminal dumb blonde syndrome? Liz, whose side is everybody on if it's not America's? Well, they must be working for the Chinese. No. Maybe it's the Russians. Well, it could be the Ukrainians. No, I know. It's the Jamaicans. No, it's the Haitians. Liz, memo to Liz. Take that head of yours out of your hindquarters. Get some preparation H, swab the ears, and listen up. That was the American people talking on January 6th. Now it's something. There's something happening here. What it is isn't exactly clear. And I think regular listeners to this show know that we're all about trying to figure out what's up with the American spirit right now. Here's what happened on January 6th, Liz. I read your committee report. You were playing the blame game so hard you wanted to make it into a giant conspiracy that you could dump on Donald Trump's doorstep. No federal prosecutor found evidence sufficient to do that, but you continue to assert that it's all Trump's fault. But here's what happened. There's a restlessness in the air, and people are dissatisfied. And many of them responded to the call of a stolen election because they thought the course the country is taking doesn't reflect their values, norms, and commitments to a place where they want to be. And so they went to stop the steal, to stop the certification of electoral votes. They went to say, stop the madness, because our lives are becoming nightmares to ourselves. And we want that sense of hope and optimism that we were taught to expect in our textbooks as kids. What's become of the American century? It's become the 21st century, and we're all lost looking for a place to be. What happened on January 6th is people went to the ellipse. They listened to Donald Trump speak about a stolen election. They believed. Whether Trump did or didn't is not the point. The point is that the elector, the president of the United States, a person who received 74 million votes, told them something, and many of them believed it. They marched on the Capitol, and when they arrived, it wasn't because of a pre-planned assault on democracy. A riot took place, and that riot was, in some individuals' cases, and at some times violent, in many cases sloppy. But neither was it a planned event. And the result was that the people, acted, and they acted because they felt their institutions were out of control. And I can think of no greater threat to democracy than a stolen election. A 3-4 hour riot that created terror in the Capitol. Yeah, I get it. That's not a good thing. But Liz, to suggest that this is the be-all, end-all, to suggest that this warrants 3.5+ years of prosecutions, to suggest that individuals should, one after the other, hundreds of them now, should be sent to prison for participating in this event is to create a permanent scab in the United States that you can't help but bleed because you want to, or pick because you want to see the blood. What's up with that, Liz, baby? What are you trying to tell us? And unless you can tell us whose side it is, I want to take your tweet here or your X. I guess if it was a tweet when it was Twitter, what is it when it's an X? I want to take your X here, and I want you to mark the spot, baby.
I don't know. A
If it's not America's side, whose is it, Liz? And this tweet of hers is probably one of the, as I look at it, might be one of the most profound things written on January 6th, because Liz will never be able to answer the question. Let's read it again. And here's the question you want to ask Liz and those who are demonizing the J6 marchers and protesters. If your response to Trump's assault on our democracy is to lie and cover up what he did, attack the brave men and women who came forward with the truth, and defend the criminals who violently assaulted the Capitol, you need to rethink whose side you're on. Hint, it's not America's. Then whose is it, Liz? And she will not have an answer to that question. What she's done is she's reacted in fear. She's played the blame game. And now she's trying to suggest that those who acted out of a sense of perhaps misplaced patriotism, perhaps a sense of dis-ease or uneasiness about the world in which they live, those who wanted the sense of significance they were taught was their birthright as Americans and came to the Capitol to protest because they don't feel it any longer. They were protesting not before someone else, but on behalf of an America that's been lost. And Liz, you're helping us lose it by this perpetual Trump bashing. You know, yes, Liz, we read Oath and Honor, your book. And yes, Liz, we know your daddy, Dick, your daddy, Richard, is proud of you. We know that. You've told us that time and again in the book. And we also know about your dedication to the quote, Constitution.
She's a Richard Rider, if you will. You know?
Yeah, no kidding. But you didn't tell us what the Constitution means. And Liz, the Constitution is a piece of paper, dear, that is infused with meaning. And the Constitution, Liz, is written in general clauses that acquire shape and context by their application to cases and controversies in each generation. Liz, dear, you didn't tell us a moment about what you believed. And in this text, in this X post, you reflect the fact that you're a naked emperor. You're an emperor with no clothes. And it's a good thing you're not sitting in the House of Representatives anymore, because based on this tweet and your analysis of current affairs and Oath and Honor, you have precisely nothing to offer the American people.
AMF to Liz Cheney, trying to deprive us of liberty. Anyway, here we go, Norm. Speaking of being naked and chains, I think maybe we should just move on to maybe messy sex. How do you feel about that?
What are you trying to tell us? So Mike thought the transitional metaphor here was chains, and then, okay, let's go to messy sex. Hi, this is Mike Boyer talking to you from the S&M dungeon here in North Carolina, where every day I begin my day by saying to my wife, anything, dear, please don't spank me again. And she says, well, I can't repeat that on family radio. So Saif Khan's case is still in the news. I represent Saif. We'll be back in court next Monday. The case involves messy sex. Two students at Yale University in 2015 heated the sheets one Halloween night, and the next day or so, the girl claimed it was without consent. Saif was thrown off campus, thrown out of college, placed on charge for sexual assault. I represented him in the criminal trial, which took place 2.5 years later, and won an acquittal, a quick acquittal. The jury, what had happened, the jury concluded, is a young woman went out for the time of her life, had it, and had regrets the next day. Saif perhaps was not a gentleman, but he certainly didn't rape her, and no crime was committed. Saif then was readmitted to Yale, but the campus was outraged, and there were petitions to bar him from campus, some 70,000 signatures on the campus petitions. And so Yale removed him from campus, even though he'd committed no crime. They engaged in something called the University-Wide Committee on Sexual Misconduct, which is a Title IX administrative tribunal that it evaluates claims of students against one another, and concluded that, in a process that is highly flawed, that the Connecticut Supreme Court basically ridiculed in a written decision not long ago, concluded that he should be removed from campus. We've been in litigation against Yale in the federal court since 2019, and among other things, what Saif is seeking to do is hold his accuser accountable. Now, when he first filed the lawsuit, he filed against Yale and Jane Doe. His accuser was given a pseudonym. Jane Doe. She's anonymous. And the reason he did that is because he was hoping to be readmitted to Yale, and Yale's policies and procedures require an accuser to be given anonymity. And so Saif thought, hey, if I'm going to go back to Yale, I better, honor its P's and Q's, so to speak. And so and that was the thinking. When the Connecticut Supreme Court recently ruled in issues related to Jane Doe, that she was no longer a student and therefore not bound by the university's honor code, it occurred to Seif that if that's the case, then she's no longer entitled to anonymity. And because he was acquitted of the various serious charges against him and brought this lawsuit in part to show what a joke sort of the Me Too era's standards were in evaluating sexual misconduct, he believes she should be named so that she can be held accountable. He did publicize her name on Twitter. The other side has now moved to dismiss on the grounds that it was a violation of the confidentiality order that he sought when the litigation was filed. I don't think the case will be dismissed on Monday. We'll argue it. We'll be filing a motion later today to remove her confidential status, and we'll see what the judge does. But hey, messy sex at Yale is turning into a civil rights epic. Yeah, 9 years later, we're still in court banging away.
Well, I know the New York Post talks about a fairly large damages award being sought. Have you talked about that at all?
No. So let's talk a little. So Seif, every lawsuit in a civil context starts with a complaint or a written summons. And the complaint contains a statement of the nature of relief being sought and then a claim for relief. And there's an ad damnum clause, a clause that talks about with some specificity what's being sought. Seif is seeking money for the loss of a lifetime worth of opportunities. He's seeking $110 million. Now, at the time we wrote that seemed like a lot. Then you see, an FBI agent in the Sandy Hook case, whose name was never put in the newspaper, and who was accused of looking like one of the parents of the dead children, and therefore was a crisis actor. A jury gave him $90 million for that. And you see the awards of the Fulton County to the Fulton County campaign workers against Rudy Giuliani. $143 million for that. Behold the man, Saif Khan. He was living in a refugee camp in Afghanistan. Members of his family had been killed by the Taliban back in the day, as it were. A brilliant young man spotted by aid workers. They concluded he had a promising future ahead of him. He was shipped off to the United States, sent to a boarding school where he says he learned to eat with the silverware for a year or two, and then went to Yale on a full ride, a neuroscience student as bright as any client I have represented. And so what Yale did is they recruited him, they brought him to Yale, and they promised him the best that Yale could offer, and they delivered a full ride. And he was on his way to a brilliant career of accomplishments when, with a flawed administrative process in response to complaints that no jury has yet determined to be true, he was thrown out of the university, held up to the world to scorn, and has lost the future that Yale had promised him. So his damage award he will seek a large damage award because what Yale promised him was everything, and what it took from him is everything, and we'll ask the jury to determine, well, what is the value of everything?
I love that. And I think it's really helpful to have the full context in the background there. It's amazing that he comes from where he comes from and is where he is. I mean, I don't know. I'd love to read about that one day, right?
Well, I'm sure there'll be books written about the case at some point.
Well, in his own words, though, I would love to read about that one day.
I'll ask him about it. But you think about his case. I recall him stumbling into our office shortly after being tossed out of Yale. We're across the street from Yale, or a block away. It's 2015, and he's suddenly in the wind, as it were, without a home, literally. And he's charged with serious felonies. We litigate those claims for a couple of years. We try his case in 2018 in the Connecticut Superior Court. He's acquitted. He then he's permitted back on campus, if ever so briefly. Now we go to a separate proceeding in 2019 before Yale administrators. They remove him from campus and expel him. We file a federal lawsuit in 2019. The claim against Yale and Jane Doe. Jane Doe's case is dismissed on application of something called the litigation privilege because her statements were made in the context of a Yale administrative proceeding. The court held she was largely like a witness in a civil trial. They can't be sued for their testimony. They have a privilege. We claim that the administrative proceeding didn't look anything like a judicial privilege, and therefore she shouldn't have been entitled to any qualified privilege or absolute privilege. We took that to the United States Court of Appeals for the Second Circuit, and now we're on another court stop. That court, because this was an issue of first impression, whether the administrative proceedings resembled judicial proceedings, we asked the Second Circuit to certify this question to the Connecticut Supreme Court. In other words, to send the question to the Connecticut Supreme Court for a decision. So they did. We briefed it up again. We argued, time passed, and the Connecticut Supreme Court agreed with us, sending it back to the Second Circuit, which has now sent it back to the district court, and we're still at it 9 years later. So the question that the Saif Khan case presents to me is deeply personal. Will I live to see the end of it? I mean, it's been 9 years old, and we haven't even started really discovery in earnest on the civil side.
Wow. And so I didn't know. I know that we didn't intend to get into the weeds here, but the passage of time is perhaps the most compelling thing for me, especially as we watch what's happened in recent years. I think at the federal level, right, with these lawsuits and the way that these lawsuits really control the chronology of events more broadly. And I think about how young he was when this stuff started. What's he doing now? And I don't know how much you're allowed to talk about, but what has this done to him during the pendency of all this? I mean, just
Yeah.
I wonder about such significant passage of time and the relationship of that event so long ago, and then his confidence in where this is going. That's not in terms of adequacy of counsel. I'm not making a statement about that.
No, I hear you.
There's such a large portion of his life at this point. 9 years to someone who was going to an undergraduate. Was going through an undergraduate degree program at Yale. That's like a third or a fourth of his life, right?
Yeah. Well, so the problem here, I mean, obviously I can't talk about our communications, and I don't want to say too much because I don't want to be giving Yale's attorneys, who will undoubtedly view this at some point, free discovery. You've got to pay. Yeah. Hi guys. Uh, light and truth, huh? Yeah, right. Turn off the switch. Lux e veritas. That's the Yale motto. He
We love you over there.
He's a remarkably bright kid. I mean, when I say he might be one of the brightest guys I've represented, that is the truth. I think that some people have said, "Hey, he should just go to another university and get on with his life." But his view was, he had such promise, such talent. This is the sort of kid who could have been president of a country, not the United States, Jackson. I know, I get it, but he and now when you troll his name, you see rape, sexual assault, and the manner in which Yale treated him was shameful. So I think what he's doing now is keeping his wits about him, and he's got family and supporters who help him survive. But I think he's all in on the litigation. His view is, Yale, you promised to give me a bright life. Yale, you reneged on that promise. Yale, you need to be accountable and to give me the financial means to live the life you promised me.
Sounds like you're saying that he's going to go to law school.
Many years ago, I studied with, and I won't say where because it always gets you upset, with one of the world's leading St. Augustine's scholars. And Herbert A. Dean, he wrote a book called The Social and Political Thought of St. Augustine, very influential book for me, at least. And he used to say, all scoundrels end up in law school. And I don't think Saif is that big a scoundrel. In fact, if he were to apply to law school, he may or may not get in. And if he got in and he passed the bar, then he would face a gauntlet in a bar examiner's character and fitness committee, where it would be claimed that because he was accused of rape, he'd have some splaining to do. And of course, he'd say, hey, we went to trial. Here are the trial transcripts. And no telling what they'd do then.
Well, I didn't intend, to suggest that while this is pending. I'm saying that perhaps there would be some sort of moral duty that he would recognize and honor what you have done for him, because I don't know that there's anybody on the planet alive today that would have given as much as you have to his case, Norm. And I don't know that there's anybody better situated to do it. So I just think that for someone who is as promising, such a high intellect, and we know that being a lawyer these days is not mutually exclusive with doing other things. I know someone here locally that's, a CPA and an attorney. It's fascinating, right? We see all the time medical doctors, JD stacks, but he may make a promising litigator, someone that can follow in your footsteps, and he would have perhaps the best reason to do so.
Why would you wish that on him?
Because I'm worried about a world without you, Norm. I really am.
I ain't nothing but a hound dog. Don't worry about that. I'm not going anywhere fast, or I'm not. I mean, I am on the installment plan as we all are. At my age, I like to say I'm rounding third, headed for home. But it happens to us all. Anyhow, let's turn away from Siphon. Thanks for the kind word, Mike. They mean a lot in tough times. What else we got today? What else is
We
going
got a
on in this
couple of things.
wonderful world of ours?
Let's put this on the screen. We'll introduce with this. I'm going to play a quick video.
Have your order on the OpenDA disqualification issue.
So I made a promise to everybody. These kind of orders take time to write. I need to make sure I say exactly what I want to, and I plan to stick to the timeline I gave everyone.
So this week
should be out tomorrow.
That's yesterday. Judge Scott McAfee in the Georgia case regarding
what the hell is the matter with him? I mean, what do they drink in Georgia in lieu of morning coffee? Vodka and orange juice? I have never seen a judge give an interview about when he's going to release an order. I mean, this guy is like, oh, there she is, the dragon woman. Oh, hey. It's funny. Did the feds really give you $450,000 of money to use on social, on advancing justice in the county of Georgia? And Mike, what became of that $450,000 according to a whistleblower?
Yeah, so the whistleblower's name is Amanda Timpson, and Amanda alleges that $488,000 that had been earmarked for what is known as the Office of a Center of Youth Empowerment and Gang Prevention. And the money was instead used for things like MacBooks and travel and other quote unquote swag. And that some of
travel to where? To civil rights grave sites with her buddy Nathan Wade in the dead of night, where they practiced headstone humping while worshiping the dead.
It gets better. Some of Ms. Timpson's colleagues apparently mocked her for her hairstyle. So
wait a minute. I am deeply, deeply sensitive to that, being 68 years old with a ponytail. You cannot mock a person for their hairstyle. That's cruel and unusual.
Well, according to this article, and again, we've got our man A.R. Hoffman reporting on this. Again, I cannot hawk his name enough. A.R. Hoffman is the man.
He really is.
I love reading his reporting on legal issues because he has such a command of all the important facts, and he doesn't misstate things. And he's got a great voice within it. But he does also say that Ms. Timpson was demoted and fired after she had kind of done her whistleblowing activity with the House Intelligence Committee. So what's on the screen here is, I think we're kind of teeing this up for another analysis of federalism. And we've talked about sort of the issue of disregarding a subpoena, a congressional subpoena, but the potential consequences, what ethical issues are at play, what legal issues are at play. And then in this case, it appears as though the tie-in to the state versus federal issue is the fact that Fani Willis's office had been given federal funds to some degree, and almost 500,000 of that is now being alleged to have been misappropriated after it had been directly earmarked. So presumably there is some interest from the federal side to understand the use of proceeds, especially when there's a credible whistleblower making allegations of some sort of misappropriation or conversion of funds for other motives. So, Norm, what do you think about what we're going to see here?
Well, I want to break this down into basic terms so that people are constitutionally literate about what's going on here. Fani Willis is a state prosecutor, and her responsibility is to enforce the penal code in Georgia. And that penal code is presumably, as a matter of constitutional law, devoted to the health, education, and welfare of the people of Georgia. So within that realm, her role as a state official is independent of what the federal government does. As you've heard us say before, the point of federalism is that there are two levels of government basically surveilling every breath you breathe. There's a state government and a federal government. The federal government is, in theory, at least one of enumerated powers, and its responsibility is not the enforcement of the state's police powers. However, they may have concurrent or overlapping jurisdiction with respect to things like guns that affect interstate commerce. And so there are a series of constitutional moves and arguments that will federalize power in the states. one way the state gets and the states are to be independent of the federal government. That's the point. I can't stress this enough. This is in the 4th episode of our con law series, which we posted not long ago. Our constitutional system is designed to be inefficient because its inefficiencies promote liberty and prevent power from being abused. Lord Acton once said, power corrupts, absolute power corrupts absolutely. And so we don't want to put too much power in one's hands. So Fani's been subpoenaed to a House Oversight Committee to give an account of how she has used money the federal government gave her. And she responded by saying, you can't subpoena my Fani, bleep, because I'm a state actor and I'm independent of you. But at the moment Georgia said yes to the federal government's offer of money, the federal government acquired some jurisdiction over how that money gets used. And so Fani's efforts to resist the subpoena by federal authorities on strict federalism grounds can, will, and must fail, because the federal government can demand accountability for the money that it gave to her. So I think she's going to ultimately, and if she chooses, so she's been subpoenaed, apparently she's resisting it. The first move in resisting a subpoena is to move to quash it. That is to go to the court under whose authority the subpoena was issued and say to a judge, do not require enforcement of this subpoena for any of whatever their valid grounds are. I tell you that in my opinion, at least, Fani's efforts to quash this subpoena on grounds of federalism will be rejected out of hand. So if she's ordered to appear and doesn't, then she may face contempt of Congress. And as Steve Bannon learned, ignoring a congressional subpoena can have penal consequences. I don't know what she'll do. She's been a grandstander. Somehow the focus of the Donald Trump litigation in Georgia has become her now. And so she may take the sort of narcissistic plunge into defiance and say, they're just doing this to me because I'm a black woman with a fat ass. I mean, I don't think that's going to happen. But if it does, she's playing with fire, and then the House would have to decide whether to refer her to the Justice Department, because the House can't prosecute her. It's the legislative branch. Only the Justice Department can do that. So if Fani defies a valid congressional subpoena after losing a motion to quash, she could face federal prosecution.
Well, I'm not holding my breath that that's going to be the outcome. Let's talk about predictions for what Judge Scott McAfee is going to do today. We have plenty of comments in the chat, but Lawyer Will is saying that it's truly bizarre to interview a judge like that. Never seen anything like that before. Usually everything is no comment. I don't know if I've ever seen a judge, or I don't know if I've even seen a reporter attempt to interview a federal judge about a pending case, or a state judge for that matter. So I think that's interesting. I'll go out on a limb here. I think that she's going to be disqualified today. I know that the prevailing wisdom right now is that that Judge Scott McAfee lacks a backbone, that he is an invertebrate, if you will, and it will make a decision that keeps him, I guess, on the ballot for the next go around when he's looking to be elected again. I know that there's a challenger to his seat coming in the next couple of years.
We are going to do the truly audacious thing here and make sure that whatever he does, we get it right. I don't think he is going to disqualify her. So you heard it here first. He's going to disqualify her. He's going to not. And the reason I think he's going to write an opinion that raises serious questions about her integrity. I think he's going to write an opinion that says there are disputes of fact that are troubling to the court, but those disputes of fact don't rise to the level of clear and convincing evidence, or whatever the legal standard is in this context. And that while troubling questions remain, and while there may be things that other tribunals, including grievance or lawyers' professional responsibility panels, may look at, there's not enough here to disqualify her on the grounds of her of alleged misconduct. Serious questions have been raised, but they've not been resolved. And what's more, there's not enough to disqualify her on the grounds of appearance of impropriety for reasons similarly stated. So I suspect a relatively long opinion, 35 to 50 pages, where he rehearses the evidence. Mike, you say he's going to pull the trigger. I say he's not. I guess we'll know by day's end.
Yeah, and I think he'll pull the trigger. Maybe that's naive, but I also think that it's important to have some expectation that we're able to notch a win here and there, right? That we are capable of putting points on the board, as it were. no matter what, though, I mean, aside from our disagreement as to what's going to happen today, no matter what, I think one thing about what we've talked about today should be noted, and that is that the battlefield has a new front in the Georgia case by way of the House Intelligence Committee's inquiry and the subpoena. And no matter what happens with this, if she remains in the case, a jury has not been seated for this case quite yet. And what is clear now is that Trump will have a better shot at, and all of the other criminal defendants will have a better shot at a fair and impartial jury, right? A jury of their peers than it would have been had this gone the way that the prosecutor's office wanted when this started. So the higher profile, the higher consciousness around this issue will expand the field of information that can be taken in by potential jurors. And we know that that is an imperfect game. You know, I'm not saying that biased jurors are what we're looking for, but it's assumed just with the DC cases, the fact that you can't get a fair trial in DC if you are of a certain member of a political class, very similar here. So no matter what, I feel like the playing field has been evened dramatically. I think that Fani has now been emblazoned as the emblem of this Georgia prosecution, good, bad, or ugly, mostly the latter. And I think that for that reason, the entirety of the co-defendant class here is made better by this process, even if Judge Scott McAfee is an invertebrate.
Yeah, well, we'll find out. That's the good news. There are only so many hours in the day, and as this day comes tick-tocking its way to a conclusion, McAfee will release his opinion, and maybe he'll even give another press conference, Lawyer Will. By the way, Lawyer Will, great dinner with your brother Pete Atkinson. I don't know if you guys are still keeping score about contact with the show and its personalities. We had dinner at the Union League last Friday night, a very nice French restaurant here in New Haven, and talked for hours about Grace and Pete's programs at the Merry Beggars, and he confessed a certain shame at some of his relatives, but not at you. Anyhow, listen, folks, so we've talked our way through a half an hour of your time. Thank you. Mike, where do people find us?
You can find us here every weekday, Monday through Friday, 8 a.m. Eastern time on YouTube, on X, and on Rumble at LawPod Daily. You can also find us on in the podcast sphere, Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. We've got a lot going on this weekend. Norm, you and I need to talk about when I am going to have a bed made for you down here in Greensboro. Can't wait to get you down this way. And then we will be back at the top of the week with a newsletter, revamped a little bit, and we'll keep kicking.
Yeah, and I want to thank all the folks who've sent me private notes. You know, I've been clear on the podcast that you know, I am out of my marital home, and that marriage is likely to be done. In fact, is done. And it's a question of formalities now. And those are grievously hard decisions to make. But, you know, I think for all of you who struggle along life's way, you know, there is a sense in which the wind moves through time. And from time to time, the wind will force a structure over and you'll reap a whirlwind. But life summons us to be courageous and to move toward that which energizes. Be careful what you wish for. So, AMF, yo-yo.
AMF, yo-yo. AMF to all of the LA aliens. We will see you on Monday. See you later, Norm.
Ciao.